Today we're going to talk about 2 decisions that came down from the Board of Immigration Appeals that could affect your case. Last week, the Attorney General, the head of the Department of Justice, issued 2 decisions that can seriously affect certain immigration cases. The first decision has to deal with DUIs. The decision in particular dictates that if somebody has more than 1 conviction for DUI, so 2 or more, during the 10-year period for cancellation and removal, you would be ineligible to apply for cancellation and removal because you will be presumed to be a person of not good moral character, so bad moral character. That's one of the requirements to apply for cancellation or removal, and therefore you would be ineligible to even submit an application for cancellation or removal, as you will be barred if you have 2 DUIs or more. It's very important that you understand this because a lot of people sometimes just simply plead guilty to the DUIs when they get detained, simply to get it out of the way. But now that could lead to you not even being eligible to apply for relief before, if you have to go to court or for any other reason involving, because we do believe this could develop into something a little greater. So for the time being, it applies only to cancellation and removal, so you need to be careful about that. The second one's a little more complicated and it has to do with motions to clarify orders. In the state of Georgia, for example, if you're convicted of a crime and sentenced to 12 months probation, generally it says that you are given 12 months confinement, meaning to jail, but that you can serve that confinement in probation instead of having to go to jail. For immigration purposes, it's as if you were sentenced to 12 months in jail. They don't give credit to the fact that you are allowed to serve that time on probation. They simply focus on the confinement language. So you would have to submit a motion to clarify through a criminal attorney that can then ask the court to clarify that the sentence was only for probation and not for any time in jail. What the court has now said is that if the motion or the order at any point says that this is for immigration purposes, meaning that you're trying to avoid immigration consequences, then the court will not validate or basically give any sort of weight to that motion to clarify, and thus you might still be ineligible to apply. Therefore, both of these decisions can be seriously problematic to most of your cases, especially cases in court. So you have to be extra careful with the way you proceed with your criminal cases. You need to make sure to have the advice from an attorney and make sure you fight these cases out unless you have any other choice. Don't just plea it out to get them out of the way. As always, if you have any questions, feel free to give us a call. You can also write us a message or a comment through Facebook. We'll be happy to answer any questions that you may have. Thank you so much for your attention. I hope you have a great day.